Kippenberger versus Board of Registration and Veterinary Medicine.
Thank you. Mr. Darling, good morning.
Good morning. May it please the Court, the initial hearing was before the single justice, and at that time, he did not have the full record. The Assistant Attorney General has been kind enough to provide this Court with the full record, and therefore, according to the Cherubino case, this Court now has the opportunity to review the entire record. The thrust of my argument relates to two features about this case that are most egregious. The first is the document that's before the Court, the final judgment and order of the Board of Licensure. That document, I sincerely think it's a paradigm. It's the apotheosis of bureaucratic malfeasance. It is an affront to this Court. When you take a look at that document and the sections that I've outlined, particularly paragraph 14, it contains 267 references to the record, and it's virtually unreadable. Throughout the hearing, I objected and presented evidence to positions taken by the Commonwealth, by the Board. They were not responded to. In the tentative order that was produced, I requested an opportunity to appear before Board members, and I was denied that. I had to make a paper submission, which I did. I objected to certain features of the tentative opinion. They were not answered. They still haven't been answered. Let me give you one example. It's a dog named Max, and in the decision of the Board, in their hyperbole and ad hominem directives against my client, which were presented to the Boston Globe and during their news conferences as far as my client being dangerous to animals is concerned. That dog was presented to my client. He did an initial evaluation of the dog. He took it outside and bunny hopped it. There was a complaint about a shoulder problem. And he sent it home with a recommendation that it take some medication and be restrained and then come back so he could continue his evaluation because he didn't have a complete diagnosis yet. He was doing the differential progression. And that was the only time the dog went to the clinic. And at the end of toward the end of the opinion of the Board, the final opinion in order, it stated that my client utterly failed to present any evidence in mitigation relating to his treatment of Max. Absolutely not true. The record reflects that. Time and time again, I went over that. I can do this with each dog, but time and time again, I went over that with the hearing officer at the appellate level, and it still hasn't been resolved yet. What's before this Court is testimony of my client as to how he proceeded with the diagnosis of that dog, testimony of the people in his office as far as the conduct of the owner was concerned, testimony by the Board's expert witness that my client provided the appropriate evaluation and diagnostic procedures to this dog, unchallenged.
The Board's expert?
Your Honor?
Mr. Darling here, the Board's expert?
The Board expert. And that's in the record, never answered. It hasn't been responded to in the appellate papers. That language appears in Volume 2, page 607, as far as my client utterly failing to present any evidence. It was overwhelming evidence that my client did the exact right thing by this dog. That is one of the experiences that I've had in this procedure, but the most outstanding one was walking into that hearing office, into the hearing room, with the outcome already determined. The score was on the scoreboard before he took the field. These people that were conducting the hearing, and especially the investigation, had an animus toward my client. It is, you can see it in the record. It emanates from the record. And I tried to cross-examine the investigator, who was one of the problems in this case, because he assembled a whole bunch of cases that shouldn't have been before the board. I couldn't continue cross-examining him because I was stopped. I was also stopped in my examination of Aaron Arnold, the executive director of the board, in order to develop the constitutional issue that's before this court. I was told that the constitutional issue was for a different forum, that constitutional issue didn't have to be raised. Well, of course, it had to be. I did. I filed a motion to dismiss at the outset of the case as far as the prejudgment activity of the board was concerned. Every single response from the board counsel has been that, consistent with the single justice, said the same thing, that a board has a dual purpose in these matters. They have a little license to investigate and to adjudicate. I agree. I have no problem with that. The single justice that heard this case was involved as, I believe, the counsel in the Craven case for the commission. Perfect case, cited by the Commonwealth, and certainly endorsed by me, because that case says no prejudgment activity should be conducted. It goes back to the Morgan case. It demonstrates that there should be a fair and open hearing. They had a closed hearing for 15 minutes, ex parte, prior to the hearing. They heard evidence, not tested evidence, but they heard allegations and made a recommendation that my client lose his license as far as a settlement was concerned for 3 years. 3 years. That's the end of his career. 3 years settle. 3 years. The ultimate decision was a 4-year revocation, but a 3-year suspension ended his practice. That was the end of him. He actually left the state. He worked as a janitor in a church. He worked as in a convenience store. He's over. He had a clinic in Magnolia. He had a clinic in Essex, Massachusetts. And I did not submit the letters that I received and his office received from former pet owners that were so touching as far as their response to the Globe article was concerned. There was a Globe article involved.
Mr. Darling, may I ask you a question? It's the Chief Justice speaking. With respect to the what you call the ex parte hearing with the executive director, it's the
Yes.
board's position that there was no determination as to sanction at that point. What that meeting was about was whether or not to go forward with the prosecution.
I have no problem with any situation that my client was involved in as far as the progression. There were several complaints here that were being assembled by a person that, given the time, I'll be happy to tell you about my experiences with him. But to have a board member issue a probable cause, and that's fine. That's what's done in the Commonwealth. It's done in various forms. But you don't have the full board sit for 15 minutes, 5 minutes longer than we're supposed to argue, and hear evidence that hasn't been tested from an ex parte person. Normally, in these cases, it's the prosecutor, but I raised Ned about it, and the executive director went instead. But the record demonstrates that there's no question, but prosecutors regularly appear before the full board, and they get a recommendation for settlement from the board. Counsel can't appear there. I wanted to go. I wanted to settle the case. I could not settle this case. And as time went on, I tried and tried. I failed. And then, at the end, I called the chief prosecutor, and he told me that the board felt very strongly about it. It would be an exercise in futility if I wanted to continue trying. Well, I went to the top prosecutor. That board was acting as a prosecutor in this case. They were all sail, no rudder, no anchor. They were out of control over there. And this court has the responsibility to review the entire record, and I respectfully submit that this court should perhaps take some evidence and finish what I had done or tried to do in my cross-examination of the investigator and the lady that appeared before the board in order to determine how these people spent 15 minutes to come up with who was going to be thrown out on the street, because my client was devastated, his career has been ended, and he deserves due process. He did not receive it. This case, it could be a substantive due process case, too. He had a liberty interest in his license and his ability to practice and his opportunity to practice. The letters that we received from his former clients were so touching.
Mr. Darling, your time is up.
All right. Thank you, Your Honor.
But thank you very much, and we will review the case carefully. Thank you. Ms. Spector?
Good morning, Your Honors. Amy Spector, Assistant Attorney General for the Board of Veterinary Medicine. Excuse me, I want to just focus on the due process issue, which is the main issue in the case, and want to emphasize, as the single justice correctly concluded, that there was no due process violation here. I think that Dr. Kippenberger's argument rests on a fundamental misunderstanding of what happened at the board's executive meeting. By no means was that meeting a hearing. It wasn't an adjudicatory proceeding. The board did not find facts or take evidence. At that meeting, the board simply approved what's referred to and appears in the record as the referral form. This is simply the form on which the board indicates its approval of having the matter referred to the legal unit for prosecution. The form does not reflect in any manner that the board has prejudged the case or otherwise violated Dr. Kippenberger's right to due process. The board has to make some initial assessment in order to refer the case to prosecution. The issuance of an order to show cause is merely a determination that the allegations that have been presented are serious enough to warrant referral of the matter for prosecution. But the board has not done any fact-finding at this point. That comes later in the adjudicatory hearing. So I think that Dr. Kippenberger's whole argument really rests on a misunderstanding and mischaracterization of what happens when the board authorizes the order to show cause and approves the referral form. In this case, the indication on the referral form of settlement terms was simply to provide guidance to the prosecutor as to what type of settlement the board might consider approving. The board, of course, has to approve any settlement that the parties might ultimately reach. And it's not in the record, but the exact nature of the settlement discussions is not in the record. But what does emerge from the record is that there were some settlement discussions which were ultimately not successful. I think the court can infer that the parties, that the prosecutor would benefit from some guidance from the board. The board, that form really just provided an indication.
But isn't that rather peculiar? I mean, in the sense that, the board must have been given some facts before it could approve the outer limits of settlement terms.
The board has before it two different things when it decides to authorize the issuance of an order to show cause. It has the consumer complaints which have been received, and it has, after the consumer complaints are received, an investigator investigates the matter. And the investigator then presents a report to the board I apologize, Your Honor, this is not reflected in the record, the exact dimensions of how this occurs. I'm presenting to you my understanding of what occurs. But the board then, with having before it the consumer complaints and the results of an investigation, makes a determination either to issue an order to show cause, as they did in this case, or not. So it's not in any sense a determination of evidence or of what the facts are. It's simply a determination that the allegations made in the consumer complaint, together with whatever information the board has gleaned from the investigation, that those two things together are sufficient to warrant the case being referred to prosecution. Now, once it's referred to prosecution and then an order to show cause issues and then the case proceeds to a hearing, only then is the board called upon through its hearing officer to make fact-finding determinations. So, again, that fact-finding doesn't occur until the case is presented in an adjudicatory hearing. It did not, in any sense, happen at the executive meeting of the board, Dr. Kippenberger's characterization notwithstanding.
It's somewhat analogous, I gather, to the clerk magistrate hearing in the district court, a show cause hearing that process should issue, determination whether or not process should issue.
I think that's right. That's right. It's an initial assessment of the allegations. But
it would be unusual for the clerk magistrate to say, and tell me on what basis I should settle this. I mean, I think if there's a perception of unfairness, it is that the board has already decided that a revocation of the license or suspension of the license. I mean, I assume that if the board is giving some guidance, the prosecutor is then not going to go and settle on terms that are inconsistent with what the board has authorized, correct?
Well, that's correct. The prosecutor cannot do so because any settlement that the prosecutor discusses with the licensee has to be
No, I understand, but if the
finally.
board has said, we think revocation of the license is appropriate, isn't the prosecutor then going to say to the respondent, I can't talk about anything other than that? I mean, that it seems to me is the perceived unfairness here, that there's been a predetermination by the board, as opposed to the prosecutor laying out the facts, doing what the prosecutor needs to do, the prosecutor making a recommendation to the board.
Well, with all due respect, I don't think so, Your Honor, because this is an indication, merely an initial indication of the board's assessment, given the seriousness of the allegations, and in this case, one of the pets died as a result of Dr. Kippenberger's mistreatment. The indication on the referral form is simply the board suggesting, we see that the allegations are rather serious. If these allegations are subsequently proved to be true, this is the type of sanction that might be appropriate, but certainly it doesn't, that initial indication doesn't bind the board. The board could, after hearing all the evidence at the hearing, the board certainly could decide on a more lenient sanction or, in this case, a more severe sanction. So I really don't think it's appropriate to think of that referral form as in any way indicating that the board has prejudged the case. It really just reflects an initial assessment based on allegations that have not yet been proven. And I just want to close by just correcting. I think Dr. Kippenberger's counsel stated something which I don't believe is correct, that the single justice did have the entire administrative record before him. The board filed it as its answer to the complaint for judicial review. In that manner, we didn't. At this level, he did not include it in his appendix, and then the board filed it as a supplemental appendix. But it also was before the single justice in the form of the board's answer.
Oh, we get the entire file, correct?
Yes, of course. Thank you.
Thank you, Ms. Spector.
All rise. Hear ye, hear ye.